I ask you this question: have we, as a society, always presumed guilt? Is that not a very human prejudice? I had my attention recently drawn to an article in The Australian in March of this year, written by Henry Ergas, who quoted the 19th century German philosopher, who said this: "There lies in every human breast a fund of hatred, anger, envy, rancour, and malice, accumulated like the venom in a serpent's tooth and waiting only for an opportunity to vent itself. And never does the venom vent more freely than when those we dislike stand accused of heinous misdeeds, confirming our prejudices and allowing hostility to morph into that most pleasurable of senses, outrage." For more than a century in New South Wales, the polity resisted the tabloids baying for blood. They resisted the outrage and applied the common law principles that so underpinned our democracy and provide the bedrock for our freedoms. Until the 1980s, when the polity, certainly the Conservatives, began an attack on the judiciary in terms of the sentences that were being imposed. Even attacks extended to the High Court when it determined Mabo, and for the first time in history, in 1992, the then Commonwealth Attorney General never defended the High Court that resulted in Sir Harry Gibbs having to make some public statements. And from that moment on, when the outrage and prejudice of the people were played on by the polity, did they begin a process of taking steps to increase incarceration by implementing in 1989 the truth in sentencing legislation, which increased incarceration periods, to the 1990s under the Carr government, where they created the standard non-parole periods that mandated standard non-parole sentences, to under the O'Farrell government, introducing changes to the Bail Act that involved massive incarcerations of people that were presumed to be innocent. We reached a stage of lack of trust of the judiciary, and the society was so outraged that they were happy for that particular result. What happened in that process to the presumption of innocence? What happened to Article 14 of the International Covenant on Civil and Political Rights that permitted everybody charged with an offence or have the right to be presumed to be innocent until proven guilty according to law? Why did the polity become so keen? How did society change and the polity become so just to deal with people simply on the basis of an allegation and have a presumption that those people were guilty? That rule of law that presumed that all people are equal before the law, what happened to that? The outrage really started to begin to infect the elected people of the Parliament, particularly the New South Wales Parliament, whereby on the first sign of an allegation, there was an expectation that an elected representative was to remove him or herself. Representative democracy requires those whom we elect are selected as a cross-section of the community, and they come into Parliament with all the strengths and weaknesses of a human being. And when there are allegations made against those people who hold public office, why aren't they judged as equal before the law like everybody else? Is it not for elected people to either be judged by we the people at election time, or if there are asserted wrongdoings, why are they not judged by the judicial arm of government to be determined by judges or judge and jury whether or not they are guilty of an offence? Why are they a different class of citizens to everybody else? I often ask myself the question is, why is it the first sign of any allegation that a political representative is removed from office? What happened to the presumption of innocence that is supposed to apply to public officials? If there is a wrong attributed to an elected person, should that person not presume to be innocent and the rule of law applied? Why is that person not judged by the judicial arm of government? And there are a litany of examples of politicians required to leave office without there being any conviction, without there being any finding of guilt, without any determination of the judicial arm of government. As far back as 1992, you might remember the then Premier Nick Greiner and the Environment Minister were removed from office because the Independent Commission Against Corruption had determined that they had acted or were guilty of corrupt conduct, a finding that was ultimately set aside by the Court of Appeal as unlawful. In 1998, Transport Minister Brian Langton was required to leave office because the Independent Commission Against Corruption said that doing what he did, and that was in opposition, they were sharing travel vouchers so that Brian Langton, as Shadow Transport Minister, could attend a meeting of citizens in June, ultimately required to leave office without being charged, let alone convicted. Premier Barry O'Farrell in 2014 was required to resigned as Premier of New South Wales, who had a massive mandate at the 2011 election because of what he called a massive memory fail in respect of an expensive bottle of wine, when he wasn't even when he was simply a witness before the Independent Commission Against Corruption. Michael Gallagher, the Police Minister, which is a case study on the failures of the Independent Commission Against Corruption, was required to leave office based upon an improper question by counsel assisting. In 2020, Shockett Mosselman, an upper house member of the Legislative Council, was raided with a federal search warrant looking for material. He was not even a suspect by the federal police, and he was required to stand down from the office that he held as assistant president and have to sit on the crossbench. Michael Johnson, only this year, the member for Upper Hunter, there was an allegation made in the New South Wales Parliament and he was forced to leave the Parliament, and no charges have been laid against him. And only about a month ago, the Minister for Family and Community Services found out from a journalist that someone had made an allegation about him, and he was required to stand down from the ministry and go and sit on the crossbench. And then we had this year, the Federal Attorney General effectively removed from that portfolio by mental gymnastics about an allegation that can never be proved that goes back some 30 years. Some of those matters I've referred to relate to the New South Wales Independent Commission Against Corruption and how they embark upon their investigation. I accept that at the time the Independent Commission Against Corruption was set up, and today, there is serious corruption occurring within the public sector, and the involvement between the public sector and private individuals that require a powerful anti-corruption body to properly resourced to undertake investigations to deter that sort of conduct. And I myself have referred matters to the Independent Commission Against Corruption that I've regarded as serious and other matters that I have heard of second and third hand can make your hair curl about the activity of certain areas of the public sector. So I accept that there is a need for a powerful corruption investigating body. However, I do say in respect of their activity that it is fundamental that the presumption of innocence always be maintained in that process. Simply by creating an organisation with Royal Commission powers for the purpose of investigating corruption does not mean that investigative body should trash people's rights or trash the presumption of innocence. In fact, it is fundamental, and it is, in my view, a bedrock to society. Currently, the Statutory Oversight Committee on the Independent Commission Against Corruption is hearing evidence from a variety of witnesses and inquiring into whether or not there should be some type of exoneration protocol. Normally, these principles of presumption of innocence, the doctrine of separation of powers, the preservation of the rights of individuals and citizens, it's normally the Bar Association and the Law Society, the legal profession, which are the bastion to protect those common law or statutory rights, and they're usually the most vocal about maintaining those rights and ensuring the actions of the government or parliament don't impinge upon them. I recently, in giving evidence before that Statutory Oversight Committee, a person by the name of Mr. Chalk, who was chair of the Public Law Committee of the Law Society, gave evidence on the 18th of September 2020. And after explaining the Law Society's view, I asked him, how do you reconcile that with the presumption of innocence? His evidence was, again, I think that they are different things. Our legal traditions have said, this is a quote, our legal traditions have set a very high bar for a criminal conviction. That's not to say that a person's reputation is otherwise immune from damage short of a criminal conviction. Regulatory bodies are constantly finding fault with people's behaviour that as an administrative decision may not result in any risk of prosecution. Health bodies finding doctors negligent, lawyers face the same regulatory findings, and in some cases, these bodies have the power to make orders that affect the rights to practice and probably go much further in those respects as ICAC can do itself. ICAC can go itself. I was surprised to hear that from the Law Society, the organisation of solicitors in New South Wales, who usually fiercely defend the rights of individuals. How you can equate a regulatory body, for example, that determines whether or not a doctor can or cannot practice, or alternatively a tribunal that determines the rights between individuals from an organisation that is funded and resourced by the state with Royal Commission powers, with the ability to go anywhere it likes, I think I regard as simply bizarre. Royal Commissions have been utilised by governments. They utilise them sparingly as an independent way of investigating a matter of great importance. But those Royal Commissions have terms of reference which defines what they may do, and that they are supposed to be used sparingly. The Independent Commission Against Corruption is a body that has Royal Commission powers and can choose to investigate whatever it wants to investigate. And in my view, a body such as that is akin to a criminal prosecution. This is a contest between an individual and the state. In fact, this is a bigger contest between an individual that's being investigated and the state, because if the state are prosecuting you, you have a whole range of protections, such as the presumption of innocence. You have protections such as the right against self-incrimination. You have protections of the right not to give evidence if you don't want to. If you're being investigated by the Independent Commission Against Corruption, you have no rights whatsoever. Having said that it is important that there be a well-resourced and powerful body to investigate corruption, doesn't mean that organisation should not have a purpose. Its purpose, in my view, should be to investigate corruption and seek to obtain admissible evidence for the purpose of bringing people to justice. That should be its chief function, because those who are in breach of their duty and those who engage in serious systemic corruption upon conviction should receive substantial periods of imprisonment. That is not what this organisation is doing. This organisation is acting in accordance with its act. It's not acting unlawfully for the purposes of rooting out corruption and bringing it to public attention through a variety of public hearings. That's inconsistent, in my view, with investigating for the purposes of charging people. And that's why ultimately the amount of people that are ultimately charged, let alone convicted, in inquiries that they have undertaken is relatively small. But whilst that process is undertaken, reputations can be needlessly trashed, and certainly society don't regard anybody whose name is mentioned as part of their process as being someone that's entitled to any presumption of innocence. I said I want to refer to Michael Gallagher as a case study as to how a powerful independent organisation that has no concept really prior to 2017 when Parliament effected a number of changes in the law. What can happen to a powerful organisation that is not effectively have a form of oversight, and how it can interfere adversely and improperly on the state's democracy. Michael Gallagher was the police minister. He was a Liberal Party member of the Legislative Council. He was leader of the government in the Legislative Council, a police minister and a former police officer with a long-standing reputation for integrity. On the 2nd of May, at a public hearing of the Independent Commission Against Corruption, whilst he was at a police passing out parade in Golden, counsel assisting put to a witness that he was examining that the witness had, quote, hatched the corrupt scheme with Michael Gallagher. Now, that assertion that had been put to that witness that Gallagher had acted corruptly was made without any warning while the minister was in Golden, and the consequences of counsel assisting's assertion caused the then Premier to demand the resignation of the minister, who for the remainder of his parliamentary term was required to sit on the crossbenches, and he was not permitted to attend Liberal Party meetings. Now, subsequently, the ICAC inspector Bruce McClintock concluded after doing an audit of ICAC that the question was inappropriate and unfair. His evidence to the Oversight Committee was that he'd examined the documents to which ICAC had relied on to make the allegation that Gallagher had hatched a corrupt scheme, and he concluded that such an assertion was not warranted or justified. The inspector concluded that it was a serious lapse of procedural fairness. He also said, unfortunately, the examination of Mr. Williams is not the only example of the conduct of Operation Spicer, which I considered to be unsatisfactory. And said that that particular inquiry by the Independent Commission Against Corruption had brought the Commission into disrepute. You wonder how you can have an organisation operating within the state that can conduct itself in that way that results in the wrongful removal of a police minister. And to this day, I'm having difficulty getting statements effectively clearing Mr. Gallagher. It's an issue that I haven't yet let go. So we have now reached a stage in our society whereby the polity sit back and are comfortable with the concept of presumption of guilt. At the first sign of any criticism, it is man or woman overboard, and at the first sign of any criticism, the concept of the presumption of innocence has now simply been relegated to a charge that a trial judge gives to the jury in a criminal trial. The effect of the evidence given by the Bar Association and the Law Society to the Committee of the Independent Commission Against Corruption is that these concepts of presumption of innocence, proof of guilt beyond reasonable doubt, these bedrocks of our entire democratic system only belong to the criminal courts. They don't belong anywhere. They don't belong anywhere else. And they use a variety of other analogies. Society seems to be to justify how one should go about how one can go about departing from these fundamental principles. So, in conclusion, I just want to thank the Rule of Law Institute for embarking upon seminars of this nature. It is really important that we just are able to see effectively the errors of our way over the last 35 or 40 years, that we stop falling into this very prejudice that Arthur Schopenhauer referred to in the 19th century, and that we can all be a part of defending these concepts, these common law concepts that have been such a fundamental part of our system. The response always by government the response always by Parliament is to take more freedoms away from citizens. It's always the first response. The first response is not an informed response that has been undertaken by, for example, an examination by the Law Reform Commission. It's a response from a newspaper headline in a tabloid newspaper, or because of criticism of a broadcaster. And so a lot of these concepts and changes are not thought out changes that are needed to address, say, shortcomings within society or within legislation or within common law. They're actually knee-jerk responses, and we need to get back to these concepts that have allowed our democracy to develop to this point, because if it doesn't, we will ultimately lose the respect of individuals. In 2017, the Parliament changed the Independent Commission Against Corruption Act by requiring it to instill in its operations for public hearings procedural fairness. You might have thought that it would have applied beforehand, but it didn't. And to provide a commissioner model to prevent agency capture. At the same time, it enacted that legislation. It had the effect of removing the then Commissioner, Justice Latham, who was the Independent Commission Against Commissioner for the Independent Commission Against Corruption. whilst I certainly supported the concept of introducing procedural fairness, it was a Parliament overreach in reaction to ICAC's overreach, which finally reached a crescendo with the Margaret Cunneen matter. But as far as I am concerned, we are at a crossroads now, and we need to start restoring these common law presumptions that so underpin our system, lest we will move completely away and we'll just allow executive government to continue to dominate. Thanks very much for having me at this webinar.